Hi, my name's Rick Selby. I'm a partner at the law firm of Dworken and Bernstein. We have offices in Painesville, Ohio and Cleveland, Ohio. I want to talk to you today about what you should do if you think you've been unfairly terminated from your job. The first thing that you need to figure out is whether you have an employment contract. Many employment contracts provide provisions that detail when an employer can and cannot terminate you from your employment. The most common type of employment contract is a collective bargaining agreement. Collective bargaining agreements exist in situations where there's a union at the company. If you're in a union and your employment is subject to a collective bargaining agreement, you'll want to talk to your union representatives as soon as possible after the termination. Generally, a collective bargaining agreement will have a provision that limits your remedies to filing a grievance. The timeline for filing that grievance can sometimes be as short as a couple days after the termination. If you have an individual employment contract that is just between you and your employer, you're going to want to review those provisions to see if the termination violated anything in the agreement. Also, you're going to want to look to see whether the agreement itself provides for any type of remedy for the termination. If you're in a situation where you don't have an employment agreement, which is most employees in Ohio, you're going to be considered an employee at will. An employee at will in Ohio can be terminated at any time for any reason, so long as it's not an illegal reason. If the employer's treated you unfairly, or is accusing you of doing something you didn't do, is giving you tasks that you believe is unfair, none of that may rise to the level of illegality. Unfortunately, in Ohio with employees at will, an employer can, in certain circumstances, treat an employee unfairly. The determination you have to make is whether that unfairness rises to the level of being illegal. In Ohio, an illegal termination is a termination that is undertaken generally for either discriminatory or retaliatory reasons. Both state and federal law provide prohibitions against employers discriminating against their employees because of race, age, gender, disability, religion, national origin, and other types of protected characteristics. Likewise, employers can't retaliate against employees for engaging in certain types of protected conduct. They can't terminate an employee in retaliation for that employee complaining about discrimination, filing a workers' compensation claim, taking FMLA leave, or other type of protected conduct. If you've been terminated, it's important that you talk to an attorney as soon as possible. Whether or not your termination is illegal is going to depend on the particular circumstances involved in your situation. Every situation is different, and it's important that you get good advice as to whether or not you have a claim. It's also important that you talk to somebody very quickly, as the timeline for bringing some of these claims can be very short. If you don't bring a claim in the time provided by law, you may have waived that claim.